All right, this is a matter of Alex Walker, this is Michael Gill, and others, and this is a hearing on a few different matters. The first issue I think I need to take up.
Could you speak up, Your
Oh,
Honor?
I'm sorry, sir. Can you hear me all right?
No.
Okay, sorry. So this is a hearing on a couple of different issues. I think the first issue I need to take up is the Mr. Gill's motion for interlocutory appeal. And so let me hear from Attorney Will, because I have not, have you seen that motion?
No, Your Honor, there's been a handful of filings that have happened in the last, I don't know, week or two that I have not received copies of. So I did receive a copy of the motion to continue this hearing. And I only received a motion, a copy of the motion prior that it came to me with the court order, and I have not received a copy of a motion for interlocutory appeal.
Okay. Mr. Gill, why were those copied on?
Yes, it's copied on it, and as important, you've already dismissed it. So what I'm saying is, for us to continue, you ruled against continuance, didn't you, Your Honor?
Against the continuance, I haven't ruled on the motion for
For
interlocutory.
interlocutory appeal, not yet. But even the continuance for being here, you're giving me 11 days to, I have 29 witnesses. And in this continuance, you saw all 29 witnesses. Now, a lot of those are adversary witnesses that I have to subpoena.
I understand, and I've explained why I denied the motion to continue in detail, in writing, and in order, so
Oh, we haven't received that yet.
uh,
But,
that went out both by email and first class.
oh, by email.
So,
Wait till we get into the emails, Ron. So I just want to make on the record that I wasn't given time to subpoena the witnesses to discuss about the emails. And
wait, Mr. Gill, how is it that you know I denied the motion to continue if you did not get a copy of the order?
because we called the clerk of courts and asked her on the phone, has the judge made a ruling? They go, well, let me look. I'll get back to you. They called me back and they said, let me get a forewoman to talk to you. And she said, well, basically, you just dismissed it. So that's why I know.
I'm the public information officer for
That's how I found out about the last hearing also, by calling the clerk of courts.
who took the photograph.
So I want you to know that this continuance, I have witnesses to bring here to deal with the paralegals. For instance, Eileen Landy. Well, listen, Your Honor, do you want to rule on the interlocutory?
Well, I'm not going to rule on it until the plaintiff has an opportunity to respond, so.
Well, you know something, Your Honor? When I don't respond, you dismiss a case.
Your Honor, if I may be heard, if your intention is to take up a motion for interlocutory appeal, I would say for the record that I object to that motion. I don't think there's any basis for interlocutory appeal in this case. There's certainly, the Supreme Court has already dismissed the regularly filed notice of appeal. Presumably, although I haven't seen the motion, the issues in the motion for interlocutory appeal are probably, I'm assuming they're the same or similar as those raised in the prior notice of appeal. I don't think there's any likelihood that the Supreme Court's going to take it, nor do I think that there's any reason to send it up now. He can appeal it, in the ordinary course at the end of this case, if that's what he desires to do. We're here today on really the two issues, as I understood from your most recent order earlier this week, really the default and the contempt.
Well, we went to Supreme Court. She denied the, because we also had this one piece open. Now, you know who it went to? Judge Conboy. They know who Judge Conboy is. It's a conflict of interest. Judge Conboy was the aide or assistant to Judge Devine. We don't even have to go, we can go more. She was a managing partner. She was the clerk for Devine. She was the managing partner for McLean, who was part of this lawsuit. So she had, excuse me, she had conflicts.
Wait.
Can I finish?
Wait, no, he can object. He has.
Well, he didn't object, he interrupted. Did you hear him say object? Neither did I.
What's the basis?
I just object around this, whatever happened in the Supreme Court in terms of whatever happened with the notice of appeal is really irrelevant.
No, it's not as corruption, Your Honor.
Well,
It's a clear conflict.
Can you stop interrupting, Mr. Gill?
He just interrupted me. You said
He has
nothing.
a right to object.
He didn't object. He interrupted. You didn't hear him say the word objection.
Your Honor, we will be here for quite a while.
Okay, Mr. Gill. The issues with respect to Judge Conboy are an issue that is not before this court. is not an issue that I can take up. I have no authority to rule on whether Judge Conboy should or should not be involved in this case, so I sustain.
Oh, I understand, but I'm
sustain
just
the
telling you,
objection.
this is in for recusal and under investigation. That's all, and they know all about it.
So I'm going to deny the motion for interlocutory appeal. I agree at this juncture of the case, the need to appeal at this point is not appropriate. These issues can all be dealt with as a final appeal when the whole case is presented to the Supreme Court.
I'd like it on the record that you're doing this intentionally to put mortgage specialists out of business by not granting the interlocutory appeal. You have this continuing on. So it's all part of the same plan. So I want it on record that this is acting corruptly and you know exactly what you're doing.
Okay. Mr. Gill, everything you say here is being recorded as part of the record.
But I just want to make it clear because I've had other pieces of evidence go missing.
Well, so I think all of the issues that you raised in your interlocutory appeal have been preserved and can be presented as part of the final appeal, and is in fact the most efficient way to deal with these claims you make. So, Attorney Will, you're ready to proceed on the other issues.
I am, Your Honor. Let's start with my motion for entry of default judgment. Your Honor, basically as a result of your order of May 10, we are back where we were at the Toronto Management Conference on April 28, which is the following. Mr. Gill filed a motion to extend discovery, which the court granted. He did not respond to my discovery requests thereafter. I filed a motion for conditional default. That motion was granted. Well, there was a clerk's sort of an administrative order that came out on the 20th of March, and that motion was formally granted on the 30th of March. 10 days came and went. No discovery responses received. To date, no discovery responses received. I filed my motion for the entry of default judgment pursuant to the Superior Court Rule 29C. And I think at this point, like I said, you're right back where you were on April 28th. There's no defense, there's no explanation, there's no excuse, and I don't think there's any inclination on the part of the defendants to comply with the rules.
I object, Your Honor.
Cooperate with some-
You do not put words in my mouth, not my intention. Speak for yourself. I do have an intent.
And so the landscape not having changed, other than the period that we went through about the notice issues and such, which are now dispensed with. There isn't a lot more to say, other than I think at this point, the entry of default judgment would be perfectly appropriate and is the next thing that should happen in the case, and that's what we're asking for today.
All right. Well, let's use your own words, Your Honor. First of all, where's the clerk of court that we're going to have as a witness? Is she here?
Mr. Gill, I issued an order on this. You did not.
No. You said, it said in the paperwork that they were going to bring the clerk as a witness.
Mr. Gill.
I brought a witness.
No, you did not comply with the order by filing an appropriate motion under oath, outlining which pleadings you did not receive. I detailed all of that in an order.
Right, and that was the clerk. All right, Your Honor, let's go. You ready? Let's use your words, okay? The next notice date, November 17th, 2000, scheduling trial management conference. Trial date states all parties copy. There is a receipt attached to the note indicating the planning council was emailed. There is no similar receipt where the defendant was sent by notice or email. So it showed the court, in your own words, I wasn't noticed. That's one. The notice of the court ordering denied defendant's motion to reconsider dismissal. There's a receipt of the notice to the email plaintiff's counsel. Then, there is no receipt for the defendant. Again, yet you filed a ruling and dismissed the case, and your own acknowledgement, I didn't receive notice.
Objection, Your Honor.
Basis.
I'm reading his own words.
Hold on, he's objecting.
We're again heading into areas that are not part of the hearing today, based on your order of May 10.
Well, I'll let this go.
The ruling is that I was notified. All right, so let's go on. Your words again, Your Honor. On November February 1st, 17, granting the defendant's request for 45 days extension. Wow, so we had notice. Now guess who you had the notice with? Eileen Landy, who was working with them and working with this court. We have evidence in that. She still has the company computer. And I also have documentation from the IT company that I wasn't on this. And you know who was on my admin account pulling off my emails? Brian Toomey, Terry Lemieux, who orchestrated my murder with Walker. They're pulling the emails. I just got this from the IT company.
Mr. Gill, stop for 1 second. Why did you not file a motion with affidavits as I directed after the last hearing?
Right, you gave me all of 11 days. I asked for a continuance to do that. You didn't grant the continuance. First of all, I have a witness that will testify to that. Can I call a witness, Your Honor?
No, you cannot, sir.
Oh.
I outlined the process that you needed to
All right,
follow.
let's keep reading your words.
Hang on. You have not followed the process in any way, shape, or form.
What
Repeatedly.
process, Your Honor? I brought a witness.
No,
You said
that's-
three witnesses.
No, I did not. Mr. Gill, I put in black and white, in writing, that you were required 3 days before this hearing to detail what your claims were and to support those factual.
I do have an
Wait a
officer
second,
response.
I'm speaking. To detail those factual assertions with sworn affidavits, which you did not do. As a
No,
result.
I brought them here instead.
No, I understand that, and I was
No, you
very.
showed me a notice with that. Listen, Your Honor, let me finish this. These are your words. Are they allowed to be in court? Your words? You just
I
said
wrote
it.
the order.
Oh, good. Then you know that on multiple occasions, we didn't receive an email. Yet you still made a judgment. Listen, let me see. On the other hand, so Eileen Landy is that. Now, Eileen Landy the information is with the FBI and U.S. Attorney. You know, Your Honor, last hearing, you turned around and said, you know, Mr. Gill, there's a difference in putting in evidence and having it investigated. Why did you say that? How did you know it wasn't being investigated? Now, the U.S. Well, you want to answer that, Your Honor? Right. So the U.S. Attorney has Brian Toomey's computer and cell phone with those communications, which is why I asked for the Corbell rule. You didn't. Now let's go on. Your own admission that I was an email. The same email who were on my account are Kerry Lemieux, Brian Toomey, and Eileen Landy, the paralegals that I said this. So the reason why I wasn't getting emails, Your Honor, is that they were working with Walker. And they had been for years, which is why I turned down $50 million, which is why Brian Toomey's in hiding. Exactly. So let's go on. And we have evidence, too, of the paralegals and the communications about the attempted murder, about setting me up in court, and about corrupting the case with Lisa Tracy. Very important, Your Honor, because you're all over that. That's the information I gave you with Ted Little. I've got emails with Lisa Tracy saying they're working with Kerry, kicking other cases out, misfiling them. And it was Brian Toomey and Kerry doing it. I had Brian Toomey admit it the day he was leaving. That's exactly what he was doing. So I am telling you that these individuals' proof, as of today, are in these emails. And you have nothing that said that I was notified. And on that last hearing, everybody knew. We had a video of 3 million people who was in Washington. And when I called here, the clerk said we notified on the 17th. And it's funny, the November 17th date does come up on here. So it wasn't out of the blue, which again, I believe that's why she's not here. So even the clerk of courts said it wasn't mailed. And then even if you turn around and make the ruling on the 8th and you mailed it on the 20th, that was 8 days. It was for a purpose. The people that are working with Walker knew I wasn't getting those emails because they were the admin on the account. And that is being investigated by the FBI and the U.S. Attorney. And you know something, Ron, you don't have to believe that. You can call Mark Hasselbecker. You can call U.S. Attorney Farley. You know, I had a video with them on the phone. So there's no doubt about this. So what I'm telling you is that each and every email, even on your own records, are saying they're getting it. Think about this. I've got 8 cases going on, all extortion, all due to the Bill Shaheen and Walker here. But let's see. I get mailed on every single case In fact, I get mail on your buddy Anderson, right here next to you. I get mail to Francois, right? The only emails I've ever got was in this case, in this courtroom, by the same Eileen Landis who's under investigation, right? Same Carrie Lemieux and Brian Toomey, who are still on the admin.
Objection, Your Honor. This is exactly what went on. We were here a couple of weeks ago. The landscape hasn't changed. Your orders have not been complied with, and we're going to spend the afternoon hearing about things that are way outside of the realm of what this hearing is supposed to be about, and frankly, what your orders have required us to do.
Objection, Your Honor. I'm reading from your order that says it wasn't received.
Mr. Gill, my orders speak for themselves. I'm granting the motion for final default judgment in this case. I've articulated in
course you
detail why I'm doing that, and I think that.
Well, we're going to appeal, and it won't be Judge Conboy,
Okay.
and it will be investigated, right? And now I have two appeals, so the interlocutory appeal is out the door now, right?
Well,
Well, you just dismissed it all. That means I can appeal.
hang on, the case is not done yet. We still have the issue of the final judgment, which, what do you propose to proceed on that, Attorney?
Okay, Your Honor, I would propose to proceed pursuant to the plea that I filed in advance of the trial management conference in earlier April. Basically, what we would propose, Your Honor, is to have final judgment entered and then have a hearing on damages pursuant to Superior Court Rule 42 in front of Your Honor. We would propose to set up a schedule of some sort, file whatever necessary pleadings on damages in advance. And we think, a day maximum.
I'll put you in jail before that.
A day maximum of an evidentiary
You
hearing.
too.
If necessary, that's what we need.
Mr. Gill, you will not address the other
Well, you're
side
talking to me.
directly. No.
You said yes, he was.
Mr. Gill, stop
Yeah,
right now. All right, I'm sorry, continue.
No, I was going to say, Your Honor, that we would ask for a hearing on damages in front of you. We think a day would do, and that could be scheduled sometime at the close of meetings in May or June.
What is the proposal in terms of discovery or disclosure of witnesses, evidence? I mean, I presume all of that needs to be done in some fashion. I'm sorry, Mr. Gill.
Oh, so you dismissed the
My question-
case and want the evidence?
The
Nice
issue,
try.
the issue at this point is what damages are
The
appropriate.
issue at this point is you guys are going to jail. Promise.
So, what's your proposal?
So, Your Honor,
Proceed with that.
we don't need discovery. I don't think at this point.
You don't want discovery. It proves that they tried to murder me. Are we figuring this out? Murder.
Mr. Gill, we're talking about the discovery of.
I know. You don't want. You're covering up the murder. And we only have a $50 million settlement from these guys. You want to ask them a question what that's for?
Mr. Gill, you've said that multiple.
Right. And you covered up for the drug dealers too. End this. You wonder why you're the same judge on both cases? You don't think the feds know about this? You do know Comey got fired. You know that, right, Walker? You should.
Your Honor, this is not the third time. Before you took the bench, he came in and called my client a profane. He referred to him.
Well, he only tried to kill me.
Mr. Gill,
He referred to him with a profane derogation, Your Honor. Now he's addressed him twice. I mean, really,
Really. He tries to kill me. You deny the evidence.
Your Honor.
You see all this evidence here? And the $50 million, did you hear him say he didn't offer me a settlement offer? Will you tell the Honor that's not true?
Your Honor,
I'm
now
lying.
he's addressing me.
okay, Mr. Gill,
Oh, so he's not saying that. Will you like to ask him, Your Honor?
Your Honor,
this is not the issue. We have.
Of course it isn't. You're covering up a murder attempt
Mr. Gill,
on 3 different occasions.
Stop.
You're not taking that evidence in. You have the Ted Little text messages from the last case. It refers to Lisa Tracy and Walker. And you know who was the lawyer? Robinstein, your best
Mr.
friend.
Gill, if you do not stop.
Rosenberg.
Mr. Gill, if you do not stop speaking at this point, you will be removed from the courtroom.
thank you, Your Honor.
Proceed.
I don't think we need discovery. I think that we need to put an evidentiary hearing on damages before Your Honor. Pretty much any time within the next, maybe June would be fine, or late May if you've got available.
You're holding my object. You're holding my accounts frozen. We'll go to
Mr.
June.
Gill, you'll get a chance.
I objected.
You will get a chance to respond. You'll get a chance to respond to this request.
Really?
Yes.
Go ahead. Like it makes a difference.
So that's what we're asking for. In the pleading I filed, we touched on an issue that Your Honor raised at the last hearing, which concerns whether that would be by jury or whether that would be in front of Your Honor. I put some citations in the pleading that stand for the proposition that a defendant who defaults thereby waives his right to request a jury. And I wanted to give the court one more citation on that today, if I could, please, because it's I think, a little closer on point. There's a case called Goldman versus Medfit, M-E-D-F-I-T. The citation is 982nd F sub 2nd, 686. At page 692, note 15, approving of essentially finding a waiver of a right to a jury for a defendant who refused to cooperate, who defaults because he refused to cooperate in discovery. So from our standpoint, that's the next proceeding in this case should be the scheduling of a day-long evidentiary hearing of damages with the opportunity to file appropriate pleas in advance of that. And if Your Honor wants to set up as well a witness and exhibit disclosure schedule, that's fine with us as well. We'd be happy to provide my idea of that.
Mr. Gill?
Right. This was the purpose of not to accept any evidence, not criminal evidence. You have evidence, Your Honor, that Alex Walker was corrupt and with those text messages. And that same person was afraid for his life.
All right, Mr. Gill, you have said this multiple
And as far as the jury trial, they don't want a jury because they would present evidence to the jury. This is done at night. So let me guess, you're going to approve no jury. Just like you've done all this. You refused all this evidence. You don't want evidence of murder. And listen, in your own words, it says that I wasn't notified. Wait a minute, Your Honor. Let me speak. You said in your own order that I was not notified, yet you gave a dismissal. Now, how do you do that?
Mr. Gill, why? So if you claim you have all this discovery, why did you not produce that discovery in response to the request?
Because I wasn't given a notice, Your Honor.
Wait.
That's why the under discovery. And then when we turned around and did get that, we asked you for that to get into it because it is criminal. Well, listen. The FBI and the U.S. Attorney has all this information. And I have filed a complaint against you too, Your Honor. And you know that.
Mr. Gill.
Don't you know that?
You can say 1,000 times.
And you can do whatever you want, because that's what you're going to do. So I'm wasting my breath. So you do whatever you want, Your Honor.
Mr. Gill,
And I'll
ask
do what I
a
want.
specific question that gets to your point. Why, if you have all this evidence, did you not turn it over to Attorney Will in response to his discovery?
There you go. You ready?
Why did
Because
you-
Eileen Landy was working for them. You got it? Eileen Landy was, and we have this evidence. They corrupted every paralegal and attorney I have. And you want to know, why do you think I'm here alone? Why do you think we have no paralegal? That was their plan. I had communications from Brian Toomey and Walker for years. 10,000 text voice messages back and forth, and those phones are with the U.S. Attorney. And also the mail from that mail fraud. Listen, we also have a precedent that I had the IRS sending me mail almost every day for 3 years. Brian Toomey and Terry Lemieux were collecting it with a guy named Curtis Morley, an accountant that I never met. They were working for Walker again. So that's mail fraud. Now listen, the United States Attorney and the FBI and I have meetings all next week in Washington with that evidence. Indisputable. Which is why you offer somebody $50 million, and if they don't take the money, that's why you try to murder them.
All right.
Now,
Mr. Gill,
one
I
last
understand
thing.
your
Not an appeal, Your Honor. Are we ignoring that they were my attorneys for about 15 years?
All right. That's an issue you can appeal when the
You better believe we're going to appeal it. But you froze our accounts. You didn't even give us the opportunity to fight back.
Your
All
Honor,
right.
I object.
All right. So
Object to what?
Your Honor, I object to this.
He object. He didn't even give a reason for objection. He doesn't want to say it. I bet you Dan will. Dan, I bet you he was on the payroll line. I bet you this guy worked for me too.
Your Honor, you are allowing him to address the court, who's very familiar with the court, in a way that if I were to do it or anyone else were to do it, we would want to be called away in contempt of court.
All right, Your Honor, you're only protecting and working for them or protecting them.
Mr. Gill.
Listen, I remember, Your Honor, attempted murder. and I have all the witnesses.
I
And you know what's
understand.
funny, Your Honor?
Okay, I
It's funny, you
understand.
might find this interesting, Your Honor. You know the guy who came in, they killed me on the second attempt? He showed up this morning. Yeah.
So
Would you like to know about that?
Mr. Gill,
I guess not.
That's not the issue here today.
My life is not the issue.
I understand your position in this case. I will take the issue about the hearing on damages under advisement and issue a written order. The remaining issue is the issue of your motion for contempt. Do you want to take up that?
Thank you, Your
issue?
Honor. Thank you. And I have a couple of exhibits I'd like to present to the court if I could.
Oh, I couldn't give you exhibits? Well, wait a minute, Your Honor, I object. You just told me no.
Oh, hold on. Have you presented that information
I
to
have.
Mr. Gill?
You'll see-
No, he hasn't.
You'll see in the exhibits that I have presented the information.
Present it, you're gonna show the mail receipt? Your Honor, wait a
May
minute.
I approach, Your Honor?
You did not allow me to put this evidence in.
I can't rule on this without knowing what this is.
Well, you didn't look at mine.
Yeah.
Oh, he just gave it to me now, Your Honor. Did he prove that he mailed it to me, Your Honor? Did he
Hold on,
prove?
Mr. Gill, let him speak.
Right.
Go ahead. Go
Thank
ahead.
you, Your Honor. Your Honor, Exhibit 1 that I've handed you, what I marked as Exhibit 1, which is behind tab 1.
Objection, Your Honor. Have you ruled on accepting the exhibits? You didn't look at mine. Are you ruling, first of all, if you're gonna rule, did he notify me? He just handed me this right now, right? So in other words, you just ruled that I couldn't use exhibits.
May I ask-
Ask him to prove.
may I ask-
I think he's trying to demonstrate that he did provide you this information, so can you?
Wait, how did he do that, Your Honor? He did it as a folder, just dropped it off to me now.
Mr. Gill. by
Well, then have him show you how to get it.
Mr. Gill, if you interrupt me one more time, you will be removed. I cannot have you continue to interrupt me and continue to interrupt Attorney Gill. That is not the way these proceedings occur. There will be an orderly process here, and if you continue to interrupt, I have no choice, Mr. Gill, but to have you removed. I do not want to do that, but you will give me no choice. Do you understand?
Oh, I understand.
You may proceed.
Thank you, Your Honor. Exhibit 1, Your Honor, is an email which I sent to Mr. Gill on Tuesday, May 9th, in compliance with your order that a list of witnesses and documents and a summary of witness testimony be provided within 3 days prior to this hearing today. The remaining exhibits in the book are the documents that I sent to Mr. Gill as part of the document disclosures that he required. Exhibits 5 and Exhibit 6 were.
Objection, Your Honor. Can he show you how I received it?
For a video clip.
Please let him finish
He
his.
just said that he sent it to me, Your Honor. There's nothing on here that said it went to me.
He's not finished yet.
Exhibits 5 and 6 were a video clip and some audio clips. And the email that I used to email all of this material to Mr. Gill is the email that I pulled from the appearance that Mr. Gill filed when he first filed his appearance in this case. And there's been no notice that email address has changed or anything else. And so that's the email address I used, and that's how I provided notice of these documents in compliance with your order, Your Honor, to Mr. Gill.
So, Your Honor, so the same email,
Wait, finish.
I'm finished with respect to establishing that I provided this information to Mr. Gill. I would then like to talk to Your Honor about what the exhibits show.
see, now these exhibits weren't received, just like it was through the email. No, I've shown you, you haven't wanted to take the evidence that shows that Karen Lemieux and Brian Toomey and Eileen were on the emails, and I haven't getting any of the emails. They're still on there. And Walker knows about it, and so does Will. That's why they don't do it by mail. See? Why not mail? And we still haven't answered. Why is it only your courtroom that I'm getting emails? It's because they know the email's been busted into. They know it's been pulled. And here are the people that did it. So in other words, they didn't show you.
Hang on. Wait. Are you willing to testify under oath that you did not receive copies of
Under oath.
Raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
So help me God.
Under pains and penalties of perjury.
Perjury, yes. Did not receive them. And Eileen Landy, that's why I wanted to bring her as a witness. I have a witness here now who will tell you that I never received them. And that we talked to the IT company. And they can verify that. Those things weren't open. And the admin on it was Eileen and Brian and Carrie that been pulling them off the whole time. I haven't got an email in months. We had shut that down. It was them. And that email's address of being investigated by the FBI.
Okay, let me ask you a question. Why, if that is true, did you use that email address as the email address to provide notice in this case?
I'm glad you asked. That was Eileen Landy. And if you look right there,
Well, wait a second, hang on. I want to follow up before you.
which emails are you referring to?
Well, I'm asking, you filed a notice of appearance in this case, correct?
When was that, Your Honor?
Beginning of the case.
Right, that's Eileen Landy. Exactly. She was the paralegal. She was doing the paperwork, Your Honor. So that's what I'm telling to you. I can prove that Eileen Landy's working with them right now. I have given that to the U.S. Attorney. So since Eileen Landy left, I want this court to know this. You ready, Your Honor? Under oath, right? Eileen Landy has the corporate and my legal computer still in her possession. I am asking the FBI and U.S. Attorney to take it from her. Okay? So in other words, the company computer, Your Honor, Eileen Landy, all the work on this case is in her possession. And I will tell you when she left. The very day Francois put me in jail. On a date that wasn't even scheduled, that she put me there and knew it. And used that money to turn around and get into the business account so Anderson could hit the business.
Okay. Hang on, Mr. Gill. I'm showing through the bailiff. Can you show Mr. Gill a copy of this? This is document number 9 in the clerk's file. Is that your signature at the bottom of that page?
That's a stamp, not my signature. You see the color of that? Eileen Landy had my stamp on all my stuff. So in other words, if you look at that, Your Honor, you'll see it was a stamp. Eileen Landy had a stamp for my paperwork. That's it. So it wasn't me. It was her. And if you allowed me time to bring her in, we'd have found that out. Listen, I have multiple forgeries here that they did. A tax return they forged.
All right, let me see that down.
You notice the color difference, Your Honor. You see how pale it is.
Do you want to see a copy?
Is that the appearance?
That's the original.
Right. That's Eileen Landy. And if we have her here, we'll find out. And I promise you it's under investigation. And the only contact that we've had with this court was one of her last days. That was it. And since then, they turned around and been pulling all the emails out. I haven't had any email in months.
Your Honor, if I might respond.
Well, let me finish.
Okay.
Go ahead.
Well, so my point is that you've already dismissed this and didn't even look at that evidence. I am telling you the paralegals have been working with them, which is why I have no help. And I can tell you, Carrie Lou, and Brian Toomey, there's a mountain of evidence. So in other words, and I ask you, Your Honor, are all your cases emailed now? Do you email all notice and hearings?
Mr. Gill, I've laid this all out in order. I'm not going to repeat the orders that I've issued in this case. I've explained in detail the process in that order. So the issue is, did you receive copies of these exhibits from Attorney Will and your...
No, I didn't, Your Honor.
Okay. And you're testifying to
And
that
did you see-
under oath.
Back under oath, I have, for instance, he just handed me this. And what he did with try to notice was an email. Listen, I bet the IT guy in writing saying I haven't got any emails in months.
So,
How's that?
wait, Mr. Gill, why did you not put that in a motion with an outrage? Let me finish my question. In response to my last order for today's hearing, why, if you have a person who's going to testify, wait, let me finish, please, would testify that your computer system, you have not been receiving emails, why did you not put that in a motion under oath as I directed in my order?
Because we didn't know till today and yesterday. Because we're trying to figure out exactly how are these emails getting interrupted. In fact, if you look at the IT thing, it's dated this morning. So I'm thinking, what could be it? So then we went to the IT company yesterday and today, and I can prove that to you, and under oath, that they turn around and say, well, this is how it's happening. You haven't opened them, but you have this guy on the account. I go, who? Brian Toomey, Kerry Lemieux, and then it's 360. I have a witness here that will tell you that Eileen Landy had access to all emails, which is how we caught early on the corruption with Walker. It was Landy herself who got the communications with Brian and Kerry that criminated Walker. They used the same process. I didn't know, because, in other words, why didn't I do this? Because I wasn't notified. The only way I got noticed when accidentally Greg Federer comes into court, goes to the clerk, and goes, oh, you got a hearing in a couple days. Otherwise, we would have never known.
But my question for you is why you did not file a motion as I directed, under oath, putting forth what you're saying here in court now. Why did you not do that in response to my order?
Because I needed time, Your Honor, which is why I asked you for time. We were still investigating. I'm finding evidence now. You didn't give us time on the last hearing or this time. You didn't give me time to subpoena witnesses, bring these people in, especially. And I asked you to do that. And I asked you and I told you the reason why. This has been a rush job on purpose. You didn't want me to subpoena witnesses. Okay? There's no record that you have me receiving those emails. None. Or those notices. Nothing. So in other words, and if we investigate this court, we're going to find out that all these other cases are getting in the mail. Now, why didn't someone mail me anything? I didn't get any mail on this case from you. Just emails. Because they knew my emails was being taken by the same people that I've accused before I even knew what they were doing. I only knew about these emails this morning from the IT. Who were they working with? All the same people that I said was working with Walker, who just happened to be the VP of the company. And the same day I went in here, they dismissed him, so he's on the run. That was no accident either, on the same day as this hearing. So, I say there is no record. I say this is fraud. And you still haven't had him ask him if I received any of these notices. He's got the one email, the same thing that they're using. Why didn't he put it in the mail, Your Honor? You know why? Because they don't want to go to jail, and they know that that email was being intercepted by those individuals. The fact that we have it with absolute certainty that those individuals are on that account and the admin and what I've accused them of, listen, I didn't know they were there. This court has made us investigate. And that's why we wanted more time. And there it is. And our investigation, piece up to this morning, proves how they took them off. And they knew it. He hasn't shown me one thing that mailed to me. Now, did he? See this little thing that he just handed me now? He didn't mail anything. And yet you took it as evidence.
All right. I understand your position. Attorney Will, what's your response?
My response, Your Honor, is that I am entitled to provide notice to the defendant through the email that he listed on his appearance. And that's what I did. Your order came out. If I had put it in the mail, I would have been out of compliance with your order because I wouldn't have gotten it 3 days in advance of the hearing. So I emailed it to him. My further response, Your Honor, would be that in some ways this is a sideshow to the contempt issue because the fact of the matter remains that the billboards in Manchester as of last night, in Nashua as of earlier this week, after service of your injunction order on the defendants, show a picture of Mr. Walker with the statement, Alex Walker attempted murder. That's really what's at the heart of the contempt issue here, Your Honor. And that is the case irrespective of whether whatever Mr. Gill might say about whether he got notice or not. All I can do, Your Honor, is do the best I can to give him notice with the information that he's provided in the court file. But what he can do is comply with your order and take those things off of the signs and off of Facebook. And that's what the contempt issue is about here, Your Honor. That's what needs to happen today.
Well, Your Honor, I'm trying to save my life. And I'm opening up. Listen, we have an audio of a man murdering me. For instance.
Did you receive the injunction order directing you to take that?
Did you email me it, Your Honor?
Mr. Gill, I'm asking you a question. Did you receive?
I didn't receive it. Did you email it?
Mr. Gill, I'm asking you. You're testifying.
I just told you no. Yes.
Okay.
Did you email it?
So
Let me guess.
please, can I finish my question?
thought you were done.
No, you keep interrupting me. So my question is, did you receive an order from this court directing you to remove the statement, Alex Walker attempted murder, from the billboards? Did you receive?
I haven't seen an order. No.
Your Honor, Exhibit 2 is the sheriff's return of service establishing that Mr. Gill was served with the attachment orders that you granted, as well as the injunction order.
They might have served it at the company.
If I may be permitted to finish, that service occurred on Mr. Gill on April 25 by both service at his house. So yes, of course he received your order, Your Honor. Of course, he was served with it. He didn't just receive it, he was served with it.
No one signed for nothing, Your Honor. I signed for nothing. Now, I'm not saying they didn't. I'm just saying that I didn't receive it. And that's why you don't have the signature. But why not? He just turned around and said, you know what, Your Honor, I had to send it by email. We didn't have time for the horror. Listen, I was asking you for time. He couldn't send it in the mail.
Mr. Gill, this
Your Honor, why isn't any of these notifications being mailed to me?
Mr.
Especially
Gill,
in your own words.
It was delivered to you in hand at your home.
No, it wasn't in hand.
Stop it.
It
It was
wasn't in here.
delivered to your home address by the sheriff, who delivered a copy of it to your home address. So, this is what I'm doing with respect to the contempt issue. You now have a copy of it. You have until Monday morning to take down any statements about Alex Walker that are on any of your billboards. If there are any statements about Alex Walker on any of your billboards as of Monday at 8 a.m., you will be held in contempt of court. Do you have any question about that?
No question. I got one question. I can still put you on my billboard, though. Is that right?
I'm not answering your question.
Well, excuse me. You're on it now. You're on it. So I can keep you on it. I'll take him off. I'll leave you on.
I would extend that request also, Your Honor, per your injunction order to Facebook. You'll see Exhibit 4.
I want to appeal that decision, Your Honor.
Exhibit 4, Your Honor, is a screenshot of the Facebook post, and I will also, with respect to video clips and audio posts, all of the stuff on the internet, it's widespread. It's everywhere.
You are ordered to comply as of Monday morning at 8 a.m. with the injunction order that I issued in this case, that you have received a copy of today in hand. And if you do not comply with that as of Monday morning, I will.
Are you saying we can't put this on Facebook, Your Honor?
Mr. Gill,
This hearing?
Mr. Gill, I will entertain a motion for contempt of court, and you will be incarcerated until you take the efforts to have that information removed as directed in the injunction. Do you understand what's required?
I understand. But, Your Honor, this is a First Amendment right. And listen, we had 3 million views. Are you saying we can't play this video, Your Honor? This is not on the sign. This is open court. Open court. So I can use this video.
My injunction speaks for itself.
Well, wait a minute, Your Honor. You need to make this clear. Can I use this video from this courtroom that's open court? That I can use this? This isn't part of public record.
Mr. Gill, I'm not going to give you advice about what you can.
No, not advice. I'm asking for clarity on the court. My intention is to play this video for a few million people. I will abide by Your Honor. I will take it off the sign. I won't add any private videos on Walker. But when it comes to this, and what's being done here, because clearly it's covering it up. They know you, and you know too. We got 3 million views on this. So, Your Honor, can you clarify this one piece, please?
All right, let me hear from Attorney Will what his response is.
Couple of things, Your Honor. One, your injunction order, which has now been served on the defendant for several weeks, or at least a couple of weeks, I gave you the map back to April 25, said that the information was to be taken off of the signs, off of the internet, immediately, Your Honor. So now, and you just heard Mr. Gill tell you that 3 million people are looking at this stuff.
Right.
So now we need to go another 3 days over a weekend where Mr. Walker's face has to be plastered all over the internet and on billboards saying attempted murder. It's a couple of keystrokes, Your Honor, to take that sign down, and it's way past overdue. The contempt is on PF There's been a complete disregard for Your Honor's orders at every step of this process. And now, the upshot is that Mr. Walker has to come back to court on Monday with yet another motion for contempt. Because in the event that this order now is not abided by, Your Honor, this would be done today, it could be done immediately.
Okay, so what's your request for relief?
My request for relief, Your Honor, is a finding of contempt and a sanction that will that will sufficiently compel Mr. Gill to abide by your order. His compliance with your order is in his hands. He controls the signs, Your Honor. He controls what he posts on the internet. It's in his hands to abide by your order. And I can tell you that the sanction that's appropriate is not going to be a fine. It's not going to be that those types of things don't work in this case. But I think that if you were to incarcerate Mr. Gill, he could then decide how long he wants to be incarcerated. He could avoid incarceration if he turns the signs off now. He could be in for a day and turn the signs off. He could be in for 2 weeks and turn the signs off.
I object, Your Honor.
But there
He's
needs to
again
be-
speaking about what I'm going to do.
There needs.
I object.
Okay, enough is enough here, Your
Sure.
Honor. This has been going on for a period of years at the busiest intersections in the state. Enough is enough, and it needs to stop now, and it can stop now. It's not an impossibility. It's eminently possible, and for this to stop today, and it needs to stop today.
All right. I mean, I'll take it off the sign today for Your Honor. How's that? All right?
And the internet as well, Your Honor.
No, Your Honor. First of all, this hearing, you haven't ruled on this hearing.
Let me hear from the
He just interrupted me again.
No, I want, so you're right, he didn't address that issue, so I want to hear from him on that.
Oh.
Go ahead.
As I said, Your Honor, I give you a sample of the internet posting.
No, but his point is, if he complies by removing past information, what happens if he posts today's hearing online?
Your Honor, to the extent that, again, your injunction was narrowly tailored. And what is enjoined, what is permanently enjoined in your injunction is statements by Mr. Gill that Alice Walker is an attempted murderer, okay? If Mr. Gill decides to post this hearing online, and there are statements that he has made in this hearing accusing Attorney Walker or suggesting that Attorney Walker or otherwise linking Attorney Walker with attempted murder, then yes, he's in violation of your order, Your Honor. The republication of something that is otherwise privileged in his first
Your Honor.
But isn't there a litigation privilege?
There's an absolute judicial privilege, Your Honor, against defamation. So what is said in the courtroom in official proceedings before Your Honor, absolutely privileged. There is no absolute privilege for the republication of that material out in other forms, like on the internet, on YouTube or what have you. And so, yes, Your Honor, the statements that are made, whether they're here or elsewhere, that are rebroadcast or published elsewhere, they violate your order, Your Honor.
Your Honor, first of all, this is a public hearing. And like Mr. Will said, it's been going on for years. So everybody knows, well, 3 million last one know what I say. So this isn't new. This is a public hearing. You can use this as evidence. This is open to the public. No, I'm not telling you I'm going to post this. I'm saying I'm going to comply. I'm going to take those off the sign. Your Honor, for you to rule on this would also be covering up for yourself, because this is also a witness to this, of what's happening here. So I'm saying I will comply to your order, but this hearing is a public record, and it's open to the public. You allowed for a camera, and that's exactly what we're doing. This is my right to be able to do this. So in other words, I need clarity, Your Honor, because my intention is to leave it on there, and that this is public record. I will adhere to your order in all cases, all situations, including I won't even wait till Monday, I'll take it off the sign. But this is a cover-up from what's happening here. And if you agree with that, then you're helping this cover-up. His own point was, they already know about this. This hearing will be the record. You let the people out there make the decision on what they see and what they hear. To turn around and cover this up is to turn around and cover it up on Facebook, which is what their intention was, for the truth not to get out. Now, I'm telling this is being investigated. So in other words, I would like you to make a decision now, Your Honor. I'm not looking forward to going to jail, so I want you to make a clear decision on this.
I'm listening to the arguments. So,
I think the one thing that was just made clear just a moment ago, Your Honor, is that it is easy to take the signs down. Mr. Gill said he can do it today. He doesn't have to wait till Monday. So I would at least request that, but Your Honor, the Facebook and the internet, I mean, that's where the 3 million viewers are routinely seeing these slanderous allegations, unproven, unfounded allegations about Alex Walker.
Well, we're not proven unfounded, Your Honor. They're with the U.S. Attorney and FBI.
It isn't right, Your Honor. This is the whole reason why we have gotten to where we've gotten here and why we're here before you today.
You know what,
So
Your
this
Honor?
is-
What we should do is have the FBI and U.S. Attorney, we give you the names and numbers, and you ask them if we don't have a case being investigated. So in other words, I agreed and reached and said, I will take it off the sign. I'll even do it tonight. I have the sign guy here. But when it comes to this is public record.
Mr. Gill, I'm going to take a break. I don't know the answer to your question. I will get the answer to your question before the end of the court today. The hearing will be in recess, but it's not concluded, so don't go anywhere. I need to do some research. I don't know the answer here to the question you raised. So I will issue a ruling. The court will be in recess. Bill, before I issue a ruling on the issue I took a recess on, I have 2 questions for you. My first question is...
You speak up, Your Honor?
Yes, I have 2 questions here before I issue a ruling on the issue I took a break on. And the first one is, you have testified here under oath that the M. Gill at themortgagespecialist.com is not an appropriate email address.
M. Gill at themortgagespecialist.com has been compromised. So I would ask this court to mail me like every other court does, please.
Mr. Gill, what email address do you use?
I don't use an email address. Not since it's been compromised. You can check, Your Honor, I have it with the IT people that there's been no emails from me there in months. I gave that email to the United States attorneys to investigate and the FBI. That's why I stopped using it. And they would turn around and still using it. So all the witnesses that I brought forward, you see on that as being, they had access still. And it was Eileen Landy who was the admin on it.
Okay, so Mr.
And
Gill,
she also has
I understand what you're saying.
the company
Mr. Gill,
computer.
I'm asking you another question. So if the court needs to get in touch with you
Mail me.
before the 3 days that it takes to get mail to people, do you have a telephone number that the court?
Yes, I do have a telephone number. I'm welcome to give it to you.
All right, I would like you to give the telephone number to the clerk of court before you leave here downstairs.
I will.
That they can reach you, okay? Now, the second question I have is, you testified under oath previously that you did not get mailed copies of any of the notices in this case, yet during the break, I looked at your motion for interlocutory appeal, and there's a notice of decision that appears to have been mailed to your home address at 69 Conley Grove Drive in Derry, New Hampshire. How do you explain that
I
you
was
did
in
not get-
Washington and having my mail picked up, Your Honor. As you guys all know that I was in Washington, right? So I'm saying I didn't tell you it didn't get mailed. I'm saying I didn't get it. And then when I asked you for the interlocutory appeals, I just put that in. So now listen, Your Honor, you know what we're doing? We're calling the clerk of
How
court.
did you get this? If somebody intercepted your mail, how did you get
Let me
this?
see that, Your Honor.
It's attached to your motion for interlocutory appeal.
Yes.
How did you get a copy of this notice of
Greg.
decision?
Greg picked it up.
And he did not give it to you?
No, we read it to me. Yes, just today at the office. He had went over to the court and picked it up. I can have him testify here, Your Honor, and we can have the clerk testify to that.
Mr. Gill, I don't need that. All right, so Mr. Gill, I'm providing to the bailiff copies of an amended order on the issue of the injunction that I took under advisement a few minutes ago in this case, and I am going to read it into the record so that there's no ambiguity that you have notice of what is required here. It's relatively short. So this court issued a permanent injunction on April 10th, 2017, document number 34. The analysis contained in that document is incorporated by reference herein. Michael Gill has raised a question during today's hearing whether posting the video of a public hearing such as today's hearing on the internet would violate the permanent injunction. This question raises serious legal and constitutional questions for which this court requires additional briefing. Pending resolution of this question, the permanent injunction is amended as follows. Except as authorized below, Michael Gill and the Mortgage Specialists, Inc. are prohibited from making any statements in any form accusing Alex J. Walker Jr. of committing attempted murder. By 11:59 p.m. Eastern Standard Time on May 12, 2017, the defendants are required to immediately remove those statements from the electronic billboards, the internet, and any other locations where the defendants have previously published those statements. Pending further order of this court, the amended permanent injunction does not prevent the defendants from publishing complete, unedited video, audio, and/or written transcripts of any court proceedings. The amended permanent injunction does not address the question of whether the defendants will be subject to additional monetary liability if the defendants choose to continue to publish statements accusing Alex J. Walker Jr. of committing attempted murder, even if those statements occurred during a public court hearing. The plaintiff shall brief that issue prior to the hearing on damages if the plaintiff seeks damages on that basis. The parties shall each submit a memorandum of law within 10 days addressing whether this court has the authority to enjoin republication of verbatim court proceedings during which the defendant made statements found to be defamatory. So that is the order I'm issuing in this case, and I will take the other procedural issues that we addressed earlier today under advisement and issue a written order on those issues.
Just for clarification on that, are you denying or holding an abeyance, or what claims motion for contempt?
I am, well, I'm denying it in the sense that I'm, as of 11:59 tonight, he is ordered to remove that material, and any issue about whether that information which remained in the public domain would go to the issue of damages. Okay.
So you're right. To the extent that the material isn't taken down or removed as of 11:59 tonight, then I presume we can renew our motion for contempt.
Absolutely, absolutely. And, you know, to the extent that those statements remained in the public domain between the time I issued the original injunction and today's hearing, that obviously goes to issues of whether the enhanced compensatory damages are appropriate or other damages may be appropriate. So those are issues we can take up in the context of that case, or that part of the case, I should say.
So, with clarity, Your Honor, that means that I can publish this hearing and continue to publish it.
The order speaks for itself, Mr. Gill.
Well, I'm asking you, is that true, Your Honor?
I'm not further modifying the order.
I'm not asking you to modify it, I'm asking you to, listen, I'm asking for a little clarity, Your Honor.
Okay, the orders, I told you, the order speaks for itself. I think
Well, can I ask you just a simple question, Your Honor? So you're saying that I can continue to run this video, and I have another video, you know, with over 3 million hits in this courtroom, and I can continue to run that. But any other separate video of Walker and murder, you are ordering me to take down.
Mr. Gill, I'm not going to give you legal advice. The order speaks for itself. The hearing is concluded.
All right.